Hi folks, and welcome back to Contract A Week 1. This is the theory stuff. We are up to part 2 of the theory videos, and we are now looking at promise theory. So let's go back to our Prezi and have a look at promise theory. Okay, so the main tenet of the promise theory is that you'll keep your promises. You won't go back on your word. Why should we do this? What's the rationale for that? Because we'll get along better and we'll get more reliable collaboration if, in fact, we are prepared to do the right thing and keep our promises. Background: Charles Fried, one of the many theories that got thrown around predominantly in the 1980s, rose to prominence in the 1980s. It draws fairly unashamedly from the will theory in that the heart, I guess, of this theory also relies on the notion of the individual doing stuff that's voluntary. So contracts arise from voluntary promises between the parties rather than being imposed by the state. Fried sees that much more in the realm of tort law and contract law as being the voluntary self-imposed nature of obligations. So it kind of adopts the freedom to contract mantra that was thrown around by the classical theorists. Contracts should be interpreted according to what was promised rather than imposing terms. So in order to interpret a contract, you've got to look at the promises that were made between the parties, minimising any scope to impose terms there. So there's the freedom from contract mantra that we saw in classical theory. It's inherently bound up with morality, and Fried is fairly unabashed about this, not seen as in any way to be shirked from in terms of building this theory. In fact, it really is at the core of the theory. So the main hallmark is the promise principle. You are morally obliged to keep your promises, and the force that makes your obligations binding is the fact that you are a moral person and you will say and do what you have said you will say and do. In contract law terms, it means that you are morally, not just legally, but morally obliged to perform your contractual obligations. As I said before, it overlaps with the will theory, and it's unabashedly moral at its core. Okay, what makes promises non-optional and binding is that we want it to be so as a way of achieving our purposes. It's desirable to attain our ends, our contractual ends, by the route of trust and promising, even if we could get there just as well without them. Close quote. Sorry, typo on the slide there. So really, for Fried, this is all about a way of seeing the world. We want our world to rely and to draw from institutions like promise. Now, what does promise itself rest on? Well, Fried kind of maps out this I guess a scale, and he said in terms of morality it all starts with respect. You have respect for other humans, and that then develops into a kind of trust, and you want trust, you want to promote trust, just generally as an objective. In terms of trust, then comes language between the parties, and then once you have language, then you can ultimately get to the stage of the parties making promises to each other. That's his, I guess, spectrum, you would say. And what he says is that morality is amplified at each step along this way. So you have a modicum of respect for someone, you then trust them, your moral obligations are starting to amplify, you converse with them, you have a language exchange with them. That's another step along the way. And I would probably say, I don't know that you could separate trusted language, because language is what builds trust, and trusting increases communication. So that's what the business literature would tell you. But then at the end, obviously at the big amplified part of the spectrum is our big P promises, the stuff that carries most moral weight. Okay, so it's really all about the promises. Once you say I do, you do it, and you will do it. Not only you will do it and you should do it, but you ought to do it because it's the right thing to do. All right, so let's have a look at the criticism of this theory. Firstly, and probably fairly obviously, some critics have said that the theory is tantamount to enforcing virtue. If promise is a good thing and it's a morally right thing to honour, then why shouldn't the law enforce all promises? Why is it only that contract law enforces promises where consideration has moved between the parties? And here I guess we just hark back to the beginning of the video where we were talking about the explanatory power of theory. And this is where, you know, critics are throwing cricket balls at this theory, and they're saying, yeah, can we knock it down with this one? It's a fairly sizable one because, you know, if you are going to say that enforceability should flow from the fact of promise, then why is it that we only selectively enforce some promises where consideration is present? And Freed doesn't really tackle it head on in terms of the way that it impacts on his theory. Instead, he mounts his own attack on what he considers the very incoherent doctrine of consideration. So that's probably a fairly large hole in the promise theory. The other thing is, and this is where I say the bottom line, it has similar problems to the classical theory, and indeed most party-based theory, what Barnett would call party-based theory. So the will theory obviously is based on looking at what the parties wanted to do. The promise theory is looking at what the party promised. Both of those kinds of theories are all well and good, but what happens when it's not apparent from what's in front of you in black and white on the paper what the parties willed to do or what the parties promised between each other? Okay, bit of a problem there, particularly where you have these kinds of theory drawing on the liberal individualism kind of notion that you shouldn't have the state intervening. So then what do you do where there's gaps? What do you do where the parties haven't promised in the case of Charles Freed? Because we do have courts stepping in that don't leave the parties without a remedy. If terms are unclear, then you may well get the court implying some terms. If unexpected situations arise, then you have the court developing doctrines like frustration, where the contract has ended because it's become something radically different to what the parties intended to do. The issue is that the more of this kind of problem that crops up with a theory, the less explanatory power it has, as I said before. So the more room for gap filling there is in contract law, the less convincing this theory is. So that's just a little look at promise theory. I do know some of my colleagues are fairly staunchly defensive of this particular theory. So again, it certainly is something that leaves plenty of room for healthy debate and discussion, which I hope will be coming up in our Zoom session this week. So that's the promise theory. Moving right along to our next theory, we have consent theory. And this theory, the dominant theme really here is about legal entitlements, okay? There's a system, and that system deals with bundles of rights, how you get rights to stuff, how you alienate those rights from yourself or transfer those rights to other people, how you deal with them. The consent theory basically conceptualizes contract law as being a system to facilitate the transfer of rights. Now, that transfer of rights is dependent on and hinges on one main thing, and that is the consent of the right owner. That's the rationale. You need to have consent before rights can be transferred. Okay, what's the background to this one? Rose to prominence in the 1980s. Again, as I said, very fertile time for theory building in contract law. Major proponent here is Randy Barnett. Barnett was particularly dissatisfied with party-based theories, as I said before, like will theory, promise theory. He made the same kinds of criticism that I just flagged for you in terms of the promise theory. They can't explain or rationalise situations where you still have enforceable contractual obligations, but they occur in what could be the absence of some indication of what the parties intended, their will, or what they promised. He said that's a fairly severe limitation on their explanatory power, so he went searching for something else, and that something else that he came up with was consent theory. He's not the only proponent, but he's probably the most well-known proponent. The hallmarks individuals have rights or entitlements, as we would call them in legal speak. Those rights are the root of contractual obligation. Now, the system of entitlements specifies the rights, who owns the rights, and the bounds of your freedom to deal with those rights. Property law tells you how you get rights. Tort law tells you how you can use rights, what the limits are. Contract law specifies how you can transfer your rights or alienate the rights that you have. Makes fairly common sense when you think about it, but there's a fundamental point here, and I kind of agree with Barnett in one way, and that is, he says, really the problem with things like will theory or promise theory is that they kind of talk about what the individuals want to do with what they've got, but really what we need to do is take a breath, take a step back and go, well, what's sitting underneath what actually causes a person to be able to say, this is what I want to do with what I've got, the will theory, or this is what I promise to you that I will do with what I've got.
Allow myself to introduce myself.
There is something underneath all that, and what is underneath all that is this system of rights, okay? You can't will to do something or promise to do something unless you have something to do it with. And so he says, have a look at the rights that are sitting underpinning all of this. More fundamental than will or promise, you have to have a right to do something before you can own with it as you will or promise. Okay, now the main thing for Barnett in terms of dealing with your entitlements is that you must not just consent subjectively, but you must provide to all outward occasion, to all outward appearance, that you have actually consented. That is, you've gone ahead and you've done something that manifests your consent. That's the big linchpin, okay?
Say yes. Say yes.
As long as an obligation, contractual obligation, can be traced back to your consent to do whatever it is that you're now being alleged to be obliged to do, then you in fact will be obliged to do it. So you need to have an objective view here as to whether or not consent has occurred. So unlike will or promise, there's not really that issue of the disconnect between what the party subjectively willed or subjectively thought they were promising, and then the difficulty of reconciling the theory with the way that the courts go about objectively looking at most things. Here, what Barnett is saying is, look at things objectively. The only real and close to empirical evidence that we have of consent is outward manifestation of consent, and that's the real thing you've got to look for. They're the major hallmarks of consent theory. Okay, so what are some of the criticisms that can be made of this theory? Ironically, there is a somewhat similar criticism that can be made of the consent theory that is a little like the criticism that Barnett made of the will theory and the promise theory, and that is what happens where you can't identify consent to a particular term or terms. What happens if there's gaps in the contract? We know that courts step in to imply terms, and we'll look at that a little later this term. So what's the story there? Does the theory fall down? Does it lose its explanatory power, as we were talking about at the beginning of the video? Barnett kind of comes up with a bit of a nifty two-step, and he says, well, really where you have situations like that, the implied term, the doctrine of implication of terms relies on a set of default rules, and those default rules being in existence, the parties have indirectly consented to those. So he kind of gets around that criticism, which is, you know, good for him. However, I guess what that doesn't address is the issue of standard form terms and conditions that the parties just don't read, and therefore they don't consent to, except in a really, you know, broad sense, in terms of getting what they want at the end of the day out of the contract. Barnett just doesn't shirk this and says, well, you know, in that particular case, the party is consenting. They're consenting to acceptance of the risk that comes along with not reading the terms and conditions. He says really the only exception there will be where the T's and C's are radically unexpected. So they're really something quite different from what would be the ordinary case, which the party can't really be deemed to have accepted as a, you know, run-of-the-mill risk when you're entering contracts of that type, for example. So again, a few holes in that theory. Again, like I said, most theories will have holes, and you've got to bear in mind these aren't theories. These aren't scientific prescriptions that will hold true in every single case, like, you know, the laws of the universe, the laws of gravity. These are kind of post hoc constructions to try and understand better what it is that the law is doing, or especially in the case of promise theory, should be doing, and how they shape our perspective on contract law and what it's all about. So that is consent theory. And that's where we'll leave it for this particular video, part 2. We'll move on to part 3 in the next video. So once again, hold that thought and come back and see me for part 3. Thanks, guys.